We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am fortunate, and you are fortunate, because I'm joined today by two outstanding colleagues, Justice Kinder and Justice Desmond. We will be hearing 6 arguments this morning. The rules are essentially as they are for live argument in our court, which is to say 15 minutes per side with no rebuttal. The first case we'll be hearing this morning is number 20-226, Commonwealth versus Blanton. And we will hear first from Attorney McKenna.
Good morning. If it please the court, Gail McKenna representing Mr. Michael Blanton in this case. This is a case that was replete with error, and we rely heavily on the collective error doctrine. But the worst of what happened here happened at the end of the trial, where the verdict here was coerced. Here what happened was, and I know that you've read the briefs, the jury here was held indefinitely without any notice of what would happen. They were just left to wonder. They did eventually on their own adjourn close to 6 p.m., but there was no information from the judge at all on when, if any time, they were to be allowed to adjourn, allowed to go home, take care of their families, or do any of those things that are so important in all of our lives. And in this
Ms. McKenna, what does the record tell us about how that impacted the jury's deliberations?
Well, Your Honor, in cases like this, which this type of error is structural in nature, although here, granted not preserved, and counsel failed to object, it goes to the fundamental integrity of the trial itself. There's no way that we can ever have confidence in this verdict.
The question of whether it was coerced or not, that's the structural error. If it was coerced, it's structural error.
Correct.
If it wasn't, then it's not. How do we know that it was actually, in fact, coerced?
Well, the problem here, Your Honor, and the reason we know that it was coerced is because we have case law that says that a jury has to be advised of what's going on, and you can't just hold a jury indefinitely. This jury had no information whatsoever from the judge. You have
a case that says that you have to tell the jurors before 6 o'clock what time they're going home.
Well, Your Honor, I think that when a jury knows the court closes at 4:30, and then that they're kept indefinitely and they're not given any information and they're simply left to wonder, that's what creates the coercion. And that's
did any of the jurors inquire?
They did not, Your Honor, not that the record shows. But it's the responsibility of the court to give instruction to the juries.
Have you sought to inquire of the jurors
I have not, Your Honor.
We do have this procedure available. It's implicit in the rules, the ethical rules. There's a case, Commonwealth versus Moore. It's about extraneous influences on the jury, and that's not sort of exactly the way you would ordinarily describe this, but it's about the same thing, right? Which is, did they think that they could never leave until they reached a verdict?
Well, Your Honor, I would suggest that this isn't an extraneous influence on the jury. This is part and parcel of what was happening at this trial. But
it's not the evidence in the record. It's something that is extra record, right? Did they somehow think they had to stay until they reached a verdict? So they reached a verdict when they otherwise wouldn't have.
Well, Your Honor, I think that this is intrinsic to what happened at the trial. I don't think it's outside of the record at all. I think it shows up clearly on the record, which is what happened here.
You understand that both Justice Kinder and I have asked you about the actual effect of this lack of knowledge on the jurors. That is not clear on the face of the record.
Your Honor, I would respectfully suggest that based on this record, what we have is a jury that went out to deliberate at 3 p.m. and then heard nothing else from the court at all. And then did ask a question, didn't get the entire case until after 4 and returned a verdict.
All right, so what time did it become coercive?
I'm sorry, Your Honor, I missed that.
At what time was it coerced?
I think at the point when the jury is held past court closing.
So at 4:35, a verdict at 4:35 is no good.
I think that what has to happen is at 4 o'clock or thereabouts, if a judge intends to hold a jury, and this judge did intend to hold a jury, what she said was, I'm just going to see what happens. I think what a judge has to do is pull the jury in and say, some of the things that we've seen in cases like the unpublished case that I cited, SOC, and there's another case that I cited where judges have taken care of those things, be it in the guise of sequestration or deadlock. But what they've talked about with juries to forestall all of this is, here are some of the things that I'm going to do to make sure that this is all right. Deliberation is up to you. Take as much time as you want. We'll get a meal for you. We'll take care of your childcare obligations.
Assume for a moment, Ms. McKenna, that we agree with you that some notice from the judge might have been a better practice under the circumstances. The question I think we're struggling with, or at least I'm struggling with, is what difference it made in this case and what record evidence you have to support any claim of coercion.
I think the difference that it makes here is that we can't have confidence in this verdict when we know that I would suggest the record shows that the jury was given no instructions and no guidance at all. And I would suggest that what the timeline shows is that this jury was rushed. They wanted to get out of there at 6. And we know that from something the judge says later on sentencing, I want to think about this. I don't want to be rushed. And here we have a jury that asks questions.
That doesn't tell us what the jurors were thinking.
Well,
what do you point to suggest that they wanted to be out by 6?
I think the fact that they were out by 6, and 6 is normally the dinner hour. This is a few days before Christmas. It's cold, it's dark, and court closed at 4:30. So, you're here holding people past court closing. And in some of the older cases where, this was condemned and we stopped doing this, like holding jurors overnight and so on, it was implicit that those kinds of things caused coercion. Same as here, that these kinds of things per se cause coercion. That, when you just hold people and you just don't give them any information, they're being coerced.
This jury was out for 2 hours?
I'm sorry?
This jury was out with the full case for 2 hours?
Well, Your Honor, I would suggest, and that's one point the Commonwealth makes, it was a small trial, it didn't take long. But I don't think it matters how long they were out. I've seen jurors in murder trials come back in a half an hour, but they came back within the court closing time. It wasn't as though they were held indefinitely and we didn't have any information given to them about when they could leave.
What day of the week was this? Do you know?
I believe it was a Thursday. And that's the whole problem, that we can't have a jury sitting there with absolutely no information. And that's what happened here. So how do we have confidence in this verdict? I think that common sense tells us that most people, as 6 o'clock is coming, they're like, they want to go. They want to go home. They want to be with their families. They want to have dinner. It's before the holidays. They want to shop. They have other things that they want to do. And so
we have no evidence of any of that. That all seems so speculative. You don't have any support that maybe one of the jurors asked the court officer or sent a note to the judge. We have nothing like that. Isn't that fair to say?
If one of the jurors sent a note to the judge, then the judge would have read that and it would be in the record. Telling a court officer is not sufficient, because what we need here is we need the captain of the ship to pilot the ship, and that's the judge. And her failure to do anything at all was an abdication of her duty. She had a duty to do something here. And I would suggest as well that the Commonwealth and the defense counsel here both also had a duty to do something and not sit there as the time just ticked by.
Do we know what the jury was told at the outset about how long the trial would last and that sort of thing?
I do know that they, the first day that they were released at 4, within the time of court closing, and I know that they all received the jury handbook that says that we wrap everything up at 4:30. And so, they're still there as the lights are going out and people are leaving and going home. And there they are, them and the judge and a couple of other people. I mean, this just isn't the way our courts operate. And our courts haven't operated like this since 1920, when there was a civil case and people were held overnight. And so we know that this is wrong, and we know that this violates people's rights, and we can't have any assurance that this is a fair and just verdict. The integrity of the system is important here. When we're looking at this case and we just don't know, because it's so out of the ordinary. We just don't see this happen, and we don't see this happen because it's not right. We don't hold people indefinitely with no information and just sort of like see what happens, which is what the judge decided to do here. So moving on, unless there's more questions here, I'm happy to answer any questions the court has. Let me talk about the second issue, which is also quite interesting, which is the failure to read the entire complaint, all of the charges at the outset of the trial. I mean, here what happened was that there was a 4th charge, which is the assault and battery with a dangerous weapon, and no one was given any notice that Mr. Blanton was being tried on that particular charge. And the reason was that that was never read to the jury. So instead, at the very end of the trial, suddenly that's an add-on. And I would suggest in those circumstances, as I've argued in my brief, that was effectively dismissed by the Commonwealth because the Commonwealth failed to insist on its right to try all of the different charges of the complaint. And
Ms.
so
McKenna, it is typical in Massachusetts for all of the charges to be read to the jury at the outset. Have you found any authority that suggests a failure to do so is reversible error?
Well, Your Honor, I would say that this is a matter of first impression. I was unable to find any cases on that, but I would suggest that the problem that happens here is that when we're telling a jury, well, first of all, we read all the charges for a matter of notice. And when we're telling a jury to hearken to the evidence and to the charges before it, we haven't told the jury to pay attention here, that there's this charge that they have to really listen to in terms of all of the evidence.
Do you have a case that constitutes an effective dismissal
Well,
of that charge?
The problem is, like I said, it's a case of first impression. I don't have a place where this has happened before. And so I'm asking the court to make some law here. And I would suggest that it's ineffective. Well, what I'm saying is it's error on the part of the Commonwealth, not that it's ineffective, because it's not the defendant's duty to insist that he's tried on any particular charge. It's the Commonwealth's duty to make sure that if they want a defendant tried on any particular charge, that they put the charge out in front of the court. The Commonwealth was
the problem I have
with
the notice argument is this: they don't know what the elements of any of these offenses are anyway. I mean, I never really focused on it until this case, but we tell them there are 2 kinds of assault, right? And then we go through some complicated. In every assault case, we say, it could be an attempted battery, or it could be a threatened battery that puts someone in fear. But they aren't put on notice of that by the reading of the words, so-and-so is charged with assault. And in fact, they listen to all the evidence in every case without having been instructed actually what exactly is relevant and not, because they haven't been instructed on the law yet. So I'm having a hard time with thinking that saying the names of the charges, and this is done even before impanelment, right? This is done to the whole veneer.
No, Your Honor, this happened after impanelment when we had our jury of 6 plus the alternates, and this was read to them, not to the venere.
After they'd been sworn? When?
Correct, Your Honor. This happened after they'd been sworn. I would agree with you in the sense that they're not fully instructed, but here they received no notice at all that this charge was being tried. And we just don't do that. I mean, we say, look, here are the counts which are being tried. And this count was not tried. It was not read out loud at a public trial that this particular count was being tried. And granted, it's not a matter that they get a full instruction at the outset, because some charges may be directed out. Here they weren't, but they don't get the full charge, but they get the sense of what's going to be in front of them and what they may be listening to, the nuances, and what generally. I'm sorry, I see that my time has expired.
Well, I think we understand your argument, and I know there are other issues here as well that that have been very well briefed.
Well, thank you, Your Honor. I appreciate your attention. I would ask that the convictions be reversed or otherwise vacated, as we've argued.
All right. Thank you very much. We'll now hear from Attorney Motherway. You're muted.
Good morning. May it please the court. Carmel Motherway, Special Assistant District Attorney for the Commonwealth. Turning to the first issue that counsel raised on behalf of the defendant, there was no structural error in this matter whatsoever. There is not a single case in the Commonwealth that requires a judge to inquire of a jury that has sat for under 7 hours from impanelment until going out to deliberate on a case which had 5 witnesses and 10 exhibits.
That's not the point, Attorney Motherway. As Attorney McKenna said, one day they're dismissed at 4 o'clock. They get, I don't know, they looked at them, but to the extent they got notice, they got a booklet or something that says court closes at 4:30. They're sent out to deliberate at 4. No one says anything. 4:30 passes, 5:30, and no one says, we'll be getting you dinner, or you'll be able to go home to your kids or your family, whatever. No one says anything to them. Why? I mean, that doesn't seem right, does it?
Well, actually, Your Honor, they knew that they could notify the court. They notified the court at 5:32 with a question regarding the substance of the case. They could easily have appended an inquiry, Ray, how long more they would be there. I would suggest that we had an experienced trial judge, we had experienced counsel. This case, that again, under 7 hours worth of testimony from impanelment.
Saying how long it is, but that doesn't solve the question. The question is, how late can you keep them without telling them anything? If it were 8:30 and they were still deliberating, would that be problematic?
It may be, Your Honor. It would depend on the facts in the case. I'm saying this is a case that depends on the facts of this case. We have to look at this case. And on this,
I'm sorry, I don't see that. I don't understand what the facts of this case have to do with it. I mean, if they had returned a verdict 20 minutes after being sent away and it was 4:20, okay, then, all right, they deliberated for a couple hours and then entered a verdict. But if they thought that that was the only way to get out of there, then who cares how many hours it had been?
well, I think one can look to the entire transcript to see the manner in which the trial court conducted this trial. The atmosphere was one of courtesy and accommodation. For instance, the judge never evinced impatience with counsel or directed them to move along in their direct or cross-examination, as can sometimes happen. At the end of the first day, the court informed the jury that she was able to devote all her time the next day to this case. That certainly would have assured the jury that she had nothing pressing on her agenda other than this case.
Yes,
And
but
by the way,
what if they did?
Your Honor, I suggest to you that they were adults. There is nothing in the record, by the way, to say that they received this booklet. That's the first time that I'm hearing that argument being made.
That's fine. That's fine. But they
so-
were dismissed at 4 o'clock, and you've said that if it were 8:30 p.m., it might be too late. How about 10:30 p.m.?
Your Honor, I'm not
No
saying.
instruction, they're still deliberating. That's
Your Honor.
got to be a problem, right?
Your Honor, I'm not going to speculate about what would happen at 8:30 or 10:30 in a hypothetical case.
Well, I think you
in
should,
this case-
because we have to figure out what the rule is, right? So
Well-
we have to announce a rule, and just saying whatever it is, this isn't good enough is not exactly guidance for a lower court.
Well, Your Honor, if the court is interested in announcing a rule, I would suggest the court would be looking to prior cases for guidance. And I suggest that the case relied upon by counsel here and cited today to this court of Commonwealth versus Salk is illustrative of some issues that could arise had the judge sua sponte declared that told the jury what she wanted to do. Salk does not support the defendant's position here. In fact, the judge in Salk sua sponte gave the jury information regarding dinner and accommodations, basically to reassure the jury. That court did that over the defense objection. And the reason that the judge did that was because it was a homicide, I believe it was in Western Mass. It was gang related. He had lost his alternates. He wanted to keep 12 people in order to, and the alternates had been left to alleged fear of intimidation by gang members expressed to the court. So they were off the jury. The judge wanted to keep that jury there so he could get this case to a verdict. It had been 10 days of an intense type of homicide trial. Now, when they returned a verdict shortly thereafter, defense counsel objected and argued that the judge's action caused the jury to come to a verdict so that they didn't have to stay overnight. And mind you, the counsel there had objected to the judge giving that information to the jury at the time that the judge did so. So the issue was preserved on appeal. And in that case, the court rejected the argument that this action on the part of the judge of sequestration pressured a jury to verdict. So if it didn't pressure a jury to verdict for the court to do that there, it can be of no avail for counsel to argue here that that case is something to be relied upon, and that the judge's actions inevitably should have been to undertake something similar to what the judge did in Salk, because that would have exposed or could have exposed this trial judge to the same kind of situation where defendant's counsel here argued that by giving those information, she was somehow pressuring them to come to a verdict.
Do you disagree with the general proposition that it's the judge's responsibility to manage the trial and to keep the jurors informed of the schedule?
I do not. I agree with that, Your Honor. As a general proposition, absolutely. There are times as well, if a jury has a question with respect to such things as when do they get dinner, where are the bathrooms, that kind of thing, the court officer is there for that. And that's generally how they communicate those kind of informal situations.
Does the court officer have to bring that to the judge?
Absolutely.
So
Absolutely. In the court,
that would be on the record.
Yes, but that never happened here, Your Honor. All we know is what happened.
But it's very odd to me. People are there's a judge telling them to go and deliberate. You're suggesting that average people are going to speak up and say, Your Honor, what the heck is this? I want dinner. And I just don't know that that's realistic at all, to put the burden on the jurors to speak up. They don't know what's normal and not normal and how it's ordinarily done.
2 points with respect to that, Your Honor. One, at the time they went out to begin their deliberations, they had just wrapped up their lunch an hour and 21 minutes before. Secondly, this jury knew without being instructed or divined that they could send a note asking a question of the court with respect to the substance of this case. So I would suggest to you, as reasoning adults, capable of coming to that very important conclusion, to make that very important communication to the court, would have reasonably apprehended that perhaps they could inquire as well if they wanted to go, or what might be next. I don't think that
The
in the
judge
facts
says
of this
deliberate.
case,
It seems different to me. The judge says deliberate, and you have a question about your deliberation. Seems like one thing. Telling the judge, yeah, we don't want to anymore, seems like something else. But I'm not sure. I'm really not sure where the burden lies here. Obviously, it would be the best practice to tell the jurors what's going to happen next. You don't run into this. And to some degree, the judge wanted them to reach a verdict that night because she was busy the next day. I'm not saying she deliberately coerced them, but she said quite late, I'm going to let this go for a while because I have to be in Martha's Vineyard or somewhere tomorrow. I don't remember what it was, but I don't know. I don't love it.
she did not communicate her schedule to the jury.
No, I agree with that. She didn't communicate their schedule to them either.
And she was conducted this trial, as I said, with courtesy and accommodation. And there was never a hint in the transcript of that.
No one is
moving things along.
saying that. No one is suggesting the judge was evil in some way.
No, but no, that's not the point, Your Honor. The point is that the pace of this trial, the accommodating nature of the judge would have made a reasoning juror that had already known divine they could send a note about something substantive and important, that they could add to that note that would inquire whether they were going to have dinner or be allowed to go.
Should the jurors be asked that question?
I think, Your Honor, again, this case was so short and lacked any complexity. It was very basic case, such that an experienced trial judge.
They had a question after about assault and battery. They had a question after an hour and a half.
Yeah, and then they came back 10 minutes later because it appeared from the record that that question was directed at the resolution of 2 counts. They were, and those 2 counts, they would have deliberated all of the facts at that point and arrived at their conclusion with respect to the other 3, and then they needed to wrap up those 2.
I don't look behind.
Had the judge told the jurors that they were going to be excused at 6 o'clock, would there have been any concern as to a rush to judgment because the jurors didn't want to come back the next day?
You know, Your Honor, I have to say that I think there might have been, because you have inconvenienced, I believe this would have been 6 jurors, 6-man jury, 6-person jury, and kept them there now 2 whole days. They were only able to begin in the afternoon of the first day. They had another whole day. The substance of the case, and this is important, was very straightforward, under 7 hours from impanelment to getting the case. As the jurors may have been somewhat irritated at being asked to come back a 3rd day, it could have redounded against either the Commonwealth or defense counsel at that point, particularly if the jury perceived one or the other, or maybe both, as having occasioned this 3rd day in the courthouse. And I would suggest that given that option of going forward and wrapping it up versus coming back another day, many juries would tend to choose the first of wrapping it up. And that doesn't imply.
I'm sorry. There's a lot of, well, if you're not done with your answer for Judge Desmond, I don't want to interrupt.
I'm sorry. I am, Your Honor.
the assault and battery with a dangerous weapon and assault with a dangerous weapon charges, how do we know they weren't based on the same act?
I'm sorry, Your Honor. They were, how do we know what?
They weren't based on the same act, that they aren't therefore duplicative convictions.
We know that, Your Honor, because despite the courts not stating that to them at the time of the instruction, the conduct of the defendant himself gave rise to the separate charges. Here we had two different weapons, a bat and the floor. We had two locations, the base of the stairs and the living room. We had two different times.
Why couldn't the push, let's say they didn't believe the baseball bat stuff. Why couldn't the act of the push or approaching to push her have supported the assault conviction? And then when he touched her, that's assault and battery. It's all one act. Why, how do we know that's not what they found?
Well, I assault by means of a dangerous weapon, Your Honor. I don't know that hands would qualify as a dangerous weapon per se.
What dangerous weapon did he batter her with?
He battered her with the floor when he banged her head into it 3 times. And that was the allegation in the complaint as well. It was delineated in the complaint that it was the floor. And going back to the differences here, there were 2 different injuries inflicted. By the means of the bat, he inflicted emotional injury from the fear and apprehension, and the concussion is which he
I'm not saying
endured.
that they couldn't have convicted. They weren't instructed they had to be separate acts. That's my question. But I think you've answered that.
And Your Honor, that failure to instruct on these facts and with the court's clarification as to the difference between an assault and a battery in her supplemental instructions, a jury could not have been confused about which act supported which charge.
All right, your time has expired. It's a complicated case and has many interesting ins and outs. So thank you both very much. Very, very helpful arguments to us. The case is submitted.
Is there anything in the record that suggests that the judge actually sent the complaints to the jury?
There is nothing in the record, Your Honor.
All right, thank you.
We are live and on the record.
Good morning. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined today by Justices Kinder and Desmond. The next case we will hear this morning is number 19-1611, Commonwealth versus Santana. The rules for argument are the same here as they are in person, 15 minutes aside with no rebuttal. And we will hear first from Attorney Malm.
Good morning, Your Honors. Matthew Malm for the defendant, ADALBERTO Santana. My intention today is to address the entrapment issue and the voir dire issue. With regard to entrapment, the Commonwealth essentially raises 2 arguments. That there was no entrapment because the police weren't consciously targeting the defendant, and also that there was no entrapment because the middleman here, Ms. Farnham, wasn't induced. But with regard to the argument about inducement, the Commonwealth is conflating inducement and entrapment.
Can you tell me, before we get to the Commonwealth's response,
Yes.
Where do you say the entrapment surfaced? Explain to me what part of the factual scenario do you say the entrapment is on display?
The entrapment occurs when Ms. Farnham reaches out to Mr. Santana and communicates, and I'm using the language from Silva, and communicates the government's inducement of her to Mr. Santana. And that inducement was to keep her in the deal, to not let her leave with her purse until they got that transaction done.
So at that point, hadn't she already agreed to procure the drugs for the officers?
Yes, Your Honor. And so that goes to my point about the Commonwealth conflating inducement and entrapment.
Okay.
There's no requirement that she be entrapped. It's just that she communicate the inducement, and that can be, so that's not explicitly stated in Silva, but it's not It's either way, it's not explicitly stated, but it is explicitly stated in US v. Valencia, which is cited in Silva, and the court explicitly says that it does not matter that the middleman in that case was not entrapped. The jury didn't.
Well, it seems to me, assuming it's not a subjective test about the officer's intent, and I suppose there's no reason it should be, that if the officers essentially hold this woman prisoner in their car, saying you can't, if you leave, you got to leave your purse here, like you have to come back, you're essentially our prisoner here. And she, desperate to not be their prisoner, reaches out to her, whatever he is, significant other, not quite husband, whatever.
20-year life partner.
Yes, 20-year life partner, if you like, and says, which I don't know, but this is, I guess, sort of her testimony. I'm being held prisoner here, and so has the money and hasn't brought the drugs back, and help, come rescue me. That might count as preying upon the weaknesses or sympathy of the significant other. How is there a substantial risk of a miscarriage of justice from failure to give that instruction?
So the risk is strong here. The substantial risk is strong because that was his only defense, was the entrapment defense. If you look at the testimony of Miss Farnham versus the testimony of the Commonwealth, the evidence from the Commonwealth, both presented enough evidence to find him guilty. And so really it was his only defense, was the entrapment defense.
She certainly could have left without her purse, right?
Do you agree that, well, I didn't see anything in the record suggesting that the officers told Ms. Farnham to do anything, let alone call the defendant. How do we arrive at inducement or entrapment from that?
And so, and I'll go back to the language in Silva, and there's no requirement of that in order to meet entrapment. That's a form of entrapment. That's a form of direct entrapment. And so the relative sentence, it's a disjunctive. And it's the issue of entrapment will not arise in the absence of some evidence showing that the government's inducement of the middleman has been communicated to the defendant. And that's what I'm arguing happened here. No requirement that on any part from the police that they were intending to get someone else or using her to get someone else, just that they induced the middleman, and that same inducement was then communicated. And then so the other part of that sentence is the or, and then it's or evidence showing that the middleman was consciously recruited by the government to induce the defendant to join in the commission of the crime. There's some language that the Commonwealth emphasizes also in that paragraph, the takes it upon himself, as in cases where a middleman takes it upon himself, there's no entrapment. But that does not reach the scenario here where the exact same inducement is communicated to the third party. Otherwise, that whole language would be superfluous, the clause I'm relying on in that earlier sentence.
In Silva, there was no entrapment, right?
In Silva, they found no entrapment, yes, Your Honor. And
in Silva, that had been kind of a 2-day campaign to get them to sell cocaine, up to a pound of cocaine, correct?
Yes, I believe the facts were not nearly as compelling as here, and quite different in many respects. I believe it occurred in a bar, and the two people were right there in front of the person. Both defendants were right there. So he heard the request initially.
And one of them was an undercover informant, correct? In Silva, one of them was an undercover informant?
I can't recall off the top of my head, but I can't say it wasn't. But I think a good distinguishing factor there was the inducement. There was no real inducement communicated to the defendant in that case. It was like, just get these guys off my back, get them the cocaine. Here, the inducement is much more significant. It was a significant other, a life partner, who was essentially being held prisoner by these two strangers, drug users, as far as she knew, and the only thing she knew to do was to reach out to her life partner.
Well, she certainly could have left without the purse, right?
She could have, but as she pointed out in her testimony, that had her ID in it. And so, and other things that were important to her. And so it wasn't really a realistic option for her.
Well,
And it wouldn't have been wise because,
the
again, it
concern
had
was
her.
the delay. Wasn't the concern the delay of the supplier coming forward? In other words, the reason that she was asked to remain in the car, or she was told not to leave unless she left her purse behind, was because there had been significant delay.
Yes, they wanted to get that deal done, and they weren't going to let her leave. And so that was an inducement to
Right.
her. Again, she doesn't have to be entrapped. It's just she has to be induced. And the inducement there was to keep her there, keep her in it, and get
Well, as
the
Judge
transaction
Desmond
done.
suggested, one option would have been for her to leave her purse there and go find the supplier and close the deal.
Well, she did actually leave the car twice, I believe is her testimony, to no avail. And
mean,
so that was her only option.
Can you tell me at the end, I may have, I found it a little confusing, at least in the briefs. Her testimony is that she then sees the alleged seller and her significant other walking together up to the car. Is that right?
Yes.
And what happens?
If I recall correctly, she said that she did not get she got the drugs from the drug dealer. So she did not get them from the defendant.
Yeah.
So they came up, I think it was Garrett was the drug dealer's name. They consummated the transaction. And then Mr. Santana got in the car with her because they were going to get a ride to get dropped off somewhere.
And the basis for the conviction in her testimony is him untying the baggie with his teeth or something. Like, where is the crime in her story?
So in her side, I think it would be there was evidence that he facilitated the transaction, that there was evidence that he went and got Garrett and made the transaction complete, can help.
And what was the prosecution's argument in closing? Was it that, I mean, I can check this, of course, myself, but was it that there is no Garrett in this story at all, and it's all about Santana, or what is the basis, the prosecutor's basis for arguing for conviction?
I cannot recall their precise argument, Your Honor. I'm sorry.
We've got obviously the transcripts.
Doesn't the Commonwealth suggest that the reason that they didn't want her to leave without the purse was because they didn't want to get ripped off? At that point, they had already given her the money, and the money had already left the car. And so if she had gone off into the wind, they would have been left in the car with nothing, and not their money or the drugs. So wouldn't that have alerted any drug dealer that something's amiss?
Well, I would respectfully argue that I think that's irrelevant to the question of the inducement. The inducement is, no, you're not leaving. You're not leaving until we get our drugs. You're not going to get out of here with your purse. You know, make it happen. Figure out a way to get Garrett back here. And so that's the inducement, and that's what she communicated to the defendant. So if there are no further questions regarding entrapment, I'll move on to voir dire. So I don't have too much time, but so I think what I want to emphasize that when analyzing these two voir dires in question, that it's important to look at it through the lens of Williams, because Commonwealth v. Williams was an important case. It certainly changed how I looked at voir dire. And I think the point of Williams is to tell trial judges to be on the lookout for, be aware of the fact that beliefs, life experiences can and should inform how a juror looks at a case and decides a case, but it should, that's a good thing. We want those kind of jurors, but it should not, but we don't want jurors where it can make them completely unable to be impartial, unable to impartially view the evidence and apply the law. And the court admitted that their jurisprudence on that point was muddled. And so I see Williams, and I think this court should see Williams, and I think it's what SJC intended as a call to arms, to trial court judges, you need to put more effort into this. You need to be on the lookout, and when it happens, you need to spend more time on it. And so with regard to juror 40, the argument there is that it was just too brief. This issue, it popped up. So it's a viewpoint that might inform her.
Juror 40 didn't think they could be impartial, right?
Yes, Your Honor. Okay. And
which is unlike Williams, where the juror thought they could be impartial.
And so that's where I'm arguing that Williams requires more. It was too short. Williams, okay, so it's a subtle, I think, and one of the issues, it's a subtle distinction that I think a lot of jurors won't pick up on between a life experience that informs, how they view, like still you can keep it in your mind and still be impartial. I think that needed to be explored. That's what Williams is saying. You need to explore that concept with the juror. And I think that's what the court failed to do. Even though Williams came out 5 months before this trial, the court failed to explore that possibility with the juror. It was just too quick. The juror might not have.
Don't we need to defer to the trial judge who is assessing by tone and body language and also words spoken, whether or not a juror is appropriate and can be fair? And how are we to reassess that?
Certainly, those are factors, those are relevant considerations that the appeals court has to acknowledge. Some things are extra record facts, but when the questioning is so short as it was in this case, it was almost as virtually, if you had that belief, it's automatically disqualifying. It almost rose to that level. So, and Williams is saying that, I think Williams is requiring a little more before we can rely on just go straight to, okay, trial court was there in person and they can make, they were able to see the body language and whatnot.
So the judge asked the juror, do you think you can be impartial? And the juror said, I don't think so, or words to that effect. That's what the record reflects, right?
Just so I'm exactly sure, I believe, and would that affect your ability to be fair in a case? And I think so. And so that's the other aspect of my argument, is that it's a case instead of the case. So there's some lack of specificity in that questioning too that required more inquiry.
So if the juror had said, no, I don't think I can be fair and impartial, you think it's incumbent upon the court to continue to ask that juror, well, have you given that serious thought, and to continue the questioning?
Based on the fact that there was literally just, okay, you raised your hand to the question about, yes, in short, Your Honor, yes. And that's because, and that's what I think Williams requires. If not, Williams is really pointless. It's not going to have any teeth until we start putting some more burden on the trial court with regard to voir dire.
Okay, your time has expired. If there are no further questions, I see none. Thank you very much. Very interesting argument. And we will be very interested, therefore, I think, to hear from your brother, Attorney Greenbaum.
May it please the court, Stephen Greenbaum for the Commonwealth in the Berkshire DA's office. I think the court appears to understand the Commonwealth's point of view. The defendant's argument about entrapment is based largely or solely upon Ms. Farnham's testimony as having raised that issue. But I think the court has seen, if you look at Ms. Farnham's testimony and what the defendant claims was the act of entrapment, which is the pressure on her to find Mr. Garrett, according to her story, and she calls the defendant for help there, all she's induced him to do by communicating that pressure on her is induced him to find Mr. Garrett and corral him in to completing the drug transaction. She's not inducing him to commit a crime. And
wait. You don't think going to get Mr. Garrett to deliver some drugs is a crime?
Not necessarily, not the crime of just, I'm not sure. She says this guy has drugs.
I
Find
think
him, I'm in trouble.
I think it's a crime.
Isn't it conspiracy?
All right, well,
minimum?
It's not the crime alleged and prosecuted by the Commonwealth, though.
Well,
That's the Commonwealth's
what was he
case,
convicted of?
distribution.
Okay, why isn't that distribution? Going and getting a guy and having him deliver some cocaine to somebody, or heroin, whatever it was in this case.
Well, the situation, she's not, her version was not that he ever got the guy to deliver cocaine. Her version is that the defendant, I forget it, Mr. Santana, suggested she contact Garrett because he might have cocaine. She contacted Garrett, and then Garrett took the money, went to get the cocaine, disappeared. According to her version, and the defendant really isn't involved in the drug transaction. He's just this guy who's involved in the drug transaction.
Oh, wait, look,
show up.
I assume our prosecutors in the Commonwealth would prosecute a guy who went to get a guy to bring some cocaine. I hope.
They might bring charges, but I think the defendant would have had a fine defense there.
All right, so
again, the Commonwealth's position is that this isn't really inducement.
Well,
particularly where
I'm not sure. I'm surprised by much of the police behavior here. So surely sometimes people take money for drugs and then run away, right? Mm-hmm. That must happen. You'd think it would happen all day long. You'd think that people would want to do a face-to-face exchange, right, in hand and in hand, not hand someone money so they can walk away.
Right.
Can the police keep someone prisoner in their car until the person their money has gone to shows back up? Is that even okay?
That's a good question. That's interesting. I'm not sure in an isolated situation, but the fact is they intended and they did arrest. She had already distributed heroin to them. Okay. They had probable cause to arrest her at that time. They weren't going to let her run away because they were going to arrest her anyway. And then she voluntarily went ahead to, when asked, said, "Yeah, maybe I can get you cocaine."
They were pretending to be drug purchasers.
They were pretending to be drug purchasers.
Might be scary people, right? Who might, because of the business they're in or their drug habit or whatever, carry serious weapons. She's taken some of their money. That can make people angry, right? So
I totally agree.
She has reason, and I think if we asked any woman, primarily women, I think, would you leave your purse somewhere and leave without it? They wouldn't say yes any more than anyone else would leave their wallet in a car or something and leave without it. I think they would feel like they couldn't leave. So to me, that's, and she calls, I don't know if the Commonwealth's position is there is no Garrett, or if the Commonwealth, what is the Commonwealth's position?
Commonwealth's position was there was no, the Commonwealth's evidence was that there was no Garrett. That when after
it's all Santana.
She contacted the defendant. They meet, well, let's say this, I won't say there's no Garrett, but that Garrett wasn't the man involved, because what I believe the testimony of the officers is that after she says she might be able to get them cocaine and tells them she's contacting the defendant, they go to a certain location. She goes up the street and gets cocaine from a man. I'm not sure they testify that at that point they identified that man as the defendant. She gets the cocaine, and almost immediately thereafter, the defendant gets in the car with her and takes his pinch of cocaine. So the implication of their testimony was that the man she got the cocaine from was also the defendant.
So I know it wasn't argued below at all or properly or whatever, but it seems to me that holding someone prisoner until you get your drugs, and then they call a loved one and describe their situation, which of course may not be true, but that's her testimony, that testimony would support an instruction on entrapment. That's how it strikes me. I don't know that it's a good defense or not a good defense, but it strikes me that it's adequate to raise the issue. If that's right, go ahead.
I would disagree with that. I want to go back to the inducement, because we can't look at that second phone call to the defendant in isolation. Now, but if you're following Ms. Farnham's version of the testimony, she testifies that, as Your Honor pictures it, she contacts the defendant, who gets her in touch with her, connects her with the drug dealer. So that first call is what got him involved in the drug deal by her version. So his later participation, he's already involved because of that initial phone call, and there was no pressure on her at that time. Now, I understand what I believe, Your Honor, is what you're talking about would better fit in is with the defendant's claim. He doesn't specifically make it about this conduct, is about whether or not this constitutes egregious misconduct.
No, I'm still talking about entrapment. We'll get to
then the Commonwealth would disagree that that the whole situation here involving this conduct would be entrapment. It might be something else wrong.
You don't need so much to get the instruction on entrapment, and it seems to me that playing on the emotions of a loved one of a prisoner is, I don't know what a jury would think, but it seems to me that that's a perfectly coherent type of inducement, like playing on someone's addiction or whatever, to say, I'm not going to be released from these scary men's car until you bring drugs. That, I don't know, that doesn't seem.
Well, we disagree in terms of what entrapment and the inducement means. I don't necessarily disagree that the conduct can be called into question, and that if it's
so you've said you don't know. Let's do egregiousness then. You've said, I don't know how to figure out substantial risk in light of that. If I think that instruction is needed and it's his only defense, I don't know.
I think what had to happen here is the issue needed to be, I don't know if it be raised before trial or after trial, but you have to have some factual finding in the lower court as to what actually happened. I mean, if the claim about this entrapment and what went on there didn't actually happen, then
it's for the jury to figure out the facts, not the trial judge.
Well, we don't know, but again, as in terms of whether or not the specific aspect of the case where she says she was trapped there, and whether that happened, there has to be some factual finding that there was by someone that the conduct that is claimed to be egregious in fact occurred. And that's not what happened in this case. You don't have that yet.
Can the police offer an addict drugs in order to get them drugs?
I'm not sure that's not what happened in this case. I would have questions, and I think our office would have questions about that, and has questions about that, and it's part of the reform in drug enforcement and prosecution policies.
Well, you say it would happen, but isn't that what Ms. Farnham testified? That she would get two of the 10, whatever they are, baggies in the bundle?
Well, that came after she had agreed after she had come to them and said, yes, maybe I can get you heroin. That's not an offer. If you get us heroin, we'll get you money. She's saying I can get you heroin, and my price is 2 bags. I mean, I think that's different than them approaching a person. If they approach someone on the street, hey, do you need heroin? If you get heroin for us, okay. If the police had done that, I think that's a problem. They didn't do that.
Her testimony is that she raised the 2 bags.
Right, but she's raising that as her fee. She has already voluntarily.
No, I understand that.
Well, at that point, then I don't think at that point I don't think that's in. I don't think at this that per se is something that police are forbidden to do. Whether as a matter of policy, we don't want them to do, because if she had said, I want $20, and they knew she was going to spend the $20 to buy 2 bags of heroin.
Yeah, that's a different story, yeah.
Yeah. I don't know.
At the end of the day, it was a ruse, isn't that right?
Excuse me?
At the end of the day, it was a ruse. They didn't have any intention of giving her the heroin anyhow, did they? Or did they?
They did give her the heroin. She had the heroin. She got her 2 bags of heroin after she got the man Eric Hunt, who she knew had the heroin, and she's the one. Hunt delivered the heroin, and she got her 2 bags of heroin. She had that, yes.
At what point were the arrests effectuated?
After, at least after the defendant got in the car and got his pinch of cocaine, there was a takedown. There was a signal to a takedown car, and so it was almost immediately after the bag of cocaine had been delivered to the officers, and the defendant had taken his pinch of cocaine from them within minutes.
And so the heroin that they gave her, they recovered from her.
I don't remember that, whether they recovered it or not. I know they never found the pinch of cocaine. And at least I think in the police officer's version of the story, the defendant, I could have this wrong, I hate to go off record. I think one of the two people said he swallowed the pinch of cocaine. Someone else said, I think Ms. Farnham testified it just got lost. So I'm not quite sure on those facts. I know that Ms.
I thought
Farnham.
there was some evidence that he said, I swallowed it before
Yes.
The lights came on because I'm an old G or something like that. Was there some
Yeah.
evidence?
I think when the takedown, when they knew the takedown was coming, or maybe when there's the purported takedown by the uniformed officers, that's when he said he swallowed the pinch of cocaine he had. Because as far as he knew at that time, the people in front were other drug buyers. They weren't undercover cops. So he's trying to protect, presumably to protect himself from any liability. That's in the Commonwealth's case. I had one other thing in my mind, but it just slipped. I did want to, not that I'm not sure it's relevant, but I always wondered, Ms. Farnham before trial had pled guilty to distribution and conspiracy of distribution of cocaine in this case. If I thought that might be a question. I don't know that she was charged with what happened with the heroin. And if there are no other questions, I'm content to rest on my brief.
Okay, thank you very much. Excellent arguments, an interesting case. Good job by both attorneys. Thank you so much. Very helpful to us.
We are live and on the record.
Good morning. Welcome to the Appeals Court. I'm Judge Rubin. I'm joined today by Judges Kinder and Desmond. The next case is number 20-594, Commonwealth versus HAJJAR. I would remind or I don't know if they've ever argued before us before, but to the extent they have, I would remind or tell counsel. Our rules are the same here as they are in the courtroom, which is to say 15 minutes per side with no rebuttal. And we will hear first from Attorney O'Brien.
Thank you, Your Honor. It's Jennifer O'Brien for the defendant on appeal, Robert HAJJAR. As you know, the defendant was convicted of motor vehicle homicide. The first argument for the defendant is whether or not the motion to dismiss should have been allowed by the judge, and whether the failure of the police to issue a citation is fatal to the Commonwealth's case. Now, as you know, Chapter 90C, Section 2 is the no fix statute, and the defendant concedes that their delay as a justification or a defense is not available to those cases involving death, which clearly here there is one. But it doesn't eliminate the need for a citation.
Where does that obligation come from?
The obligation to
Issue a citation rather than an indictment.
Well, I would point to the Cameron case where it's stated specifically that the amendment, the 1986 amendment to Section 2, does not eliminate the obligation to issue a citation. And
Well, that was in response. I don't know why I'm getting an echo here. Is that someone's speaker that's on or something? I don't know. That was in response to the officer's suggestion that he couldn't write a citation at the scene for anything until he discovered whether the victim would die or not. The statute itself says that the provisions of the first sentence shall not apply to any complaint or indictment. And there was an indictment here. I don't understand why you're saying there's an obligation to issue a citation rather than an indictment, which I take it is this whole argument, right?
Yes, it is. Well, it's if you look at the requirements of 90C, it's to provide notice. And
Yes, but that defense is not available to you.
the delay defense, you're saying, yes.
I don't understand how if instead of getting an indictment, you'd gotten a slip of paper in triplicate from one of those books on the very same day, how your client would have had any more or less notice than the indictment gave him.
Well, if he got it the same day, he would have been on notice the same day,
The
obviously.
same day as the indictment.
Yes, yes, I understand what you're saying, but we're arguing in this case that there was an unreasonable, the defendant's due process rights were violated because he was
Had
not.
the statute of limitations run?
It had not.
So how is any right violated if he doesn't have a 90C defense?
If he doesn't have a 90C defense, I mean, our argument is looking at the purposes behind, I guess, the 90C, which is to afford the defendant prompt and definite notice of the nature of the alleged.
Unless it's a 24G case.
Unless it's a 24G case, but again, with the Cameron case is obviously the case that we're relying on, where it specifically says that they have to issue a citation. So that's,
it doesn't say that the obligation isn't removed by that last sentence.
I agree with you there, Your Honor. Here, the defendant spoke with the police immediately after, gave a statement, and he was told that accidents happen, that it's the beginning of an investigation, and I'm sure you'll be contacted to know the outcome. And he wasn't contacted until 30 months later.
Surely that happens in criminal cases.
It does happen, Your Honor, but I think, again, if Your Honor obviously isn't agreeing with
well, I just don't see. Look,
yeah,
you may have a due process argument if you were here saying he was told he wouldn't be charged, and so he threw away all the evidence. Then we might have something to talk about. But
yes. Well, he did throw away the evidence. He turned in his motor vehicle. He didn't have it examined, and he proceeded, obviously, went on with his life for 30 months and thought that nothing was going to happen, and then it did. So, it's obviously difficult in a situation like this for the defendant to prove to prove prejudice. So I'll move on to my second argument, which I believe is hopefully a better argument, but that's the required finding of not guilty.
Before you move on, wasn't he on notice that on the day of the incident, he went back, he had an interview with the police? Didn't they explain to him then that this was the initial stages of the investigation and there was still more to be done, and
yes, absolutely,
that was an ongoing event?
Yes, they told him that this is the beginning stages. You're not under arrest. They're going to finish the investigation, and I'm sure they will contact you to let you know the outcome. And they also said that accidents happen. So based on that and the passage of 30 months, our argument is the defendant was not put on notice. He didn't flee the scene. He didn't commit a different crime. So much time passes where a police officer says that to you, you think that the case is over. And he wasn't put on notice, which is the purpose of that statute.
But,
and that's essentially our argument.
I don't want to put too fine a point on it, but you would agree that in cases investigated by a grand jury, there is no requirement for advance notice to any suspect. Yes,
yes. And usually there's no statute with other crimes that say the defendant has to be put on notice. That obviously anything involving motor vehicles, there is a statute out there, whether it applies or doesn't apply to death, that says a person has to give notice. And regular assault and battery statutes don't have that specific requirement, or any other crime that I'm aware of. So with respect to the second argument, I'll move on, the required finding. I think it's obviously a negligence standard here, and we're looking at the reasonable person standard and whether the defendant, what he did was reasonable under the circumstances. And I think a big problem for the Commonwealth, assuming, again, taking the evidence in the light most favorable to the Commonwealth, and assuming the defendant did look down for 1.5 seconds, so whatever it was, don't we have to know what he looked down at to determine whether or not his conduct was reasonable or whether it was negligent? If he was texting, certainly.
He didn't. He said he looked away because maybe he was shuffling some clothes that were in the chair. He had no way of knowing what he was looking down at.
And I think that's a problem for the Commonwealth, though, because don't we have to know what he looked down at to determine whether he's a reasonable person? I'm sure everybody driving to work today didn't have their eyes on the road the whole entire time, whatever their commute was. It's human nature to, maybe check something, or, if he was fidgeting around with the radio for 3 seconds, sure, that's probably reckless, negligent. But if we don't know what he was looking down at, I don't know how the
You
one.
can't look down. What can you look down at? What are you allowed to look down at while you're driving?
I think human nature, you do.
Yeah, but you just said looking down at the radio isn't okay. People do that kind of thing all the time, but
Well,
that's not okay.
Well, the prosecutor said in the closing argument that is okay, actually. I would argue, for 3 seconds looking down and fooling around with your radio when you hit somebody, obviously not. You have to look in your side mirror before you change lanes to make sure no one's.
Maybe people are all driving negligently and they're just lucky they didn't kill anybody. I'm not sure, but I do think, people now, especially with phones and so on, they look at their GPS. Now, I don't know if I don't see that that's inherently okay. They take a phone call, they try to switch on their headset because it's not paired properly with their Bluetooth, right? People do all these things that probably they shouldn't. But I'm not familiar with you're allowed to take your eyes off the road for a second.
I think that's a jury question. I think that's
actually. Oh, that's right. That's why the
point. But here we don't know what he looked down at. Assuming he looked down, we have no idea. Was it like instinctive? Was it non-voluntary? Did he just? We're human beings, I think, and that was what was argued below. Like certain things, if you're not acting intentionally or reckless or negligently, if you hear a noise, somebody's going to turn and look, and that's just being a human being.
But we don't need to assume that he looked down. He concedes that he looked down, right?
Well, he does. He said he looked down for a second and looked up, and she was right in front of him. But we know that wasn't true because he did brake.
Wasn't there competing expert testimony as to the length of time that he looked away? Or the length of time that he would have had to react before striking the pedestrian?
There was, and my argument takes the evidence in a light most favorable to the Commonwealth, which is a 1.5 seconds to see the danger and to start to react, and then 2 seconds to stop the vehicle, which in my math is 3.5 seconds. So if she was visible at 5 seconds, then that assumes for 1.5 seconds, he should have seen her and didn't see her, whether he was looking down, whether he looked down for 1 second, and then it took him 0.5 seconds to react. We don't really know. And to have criminal culpability for 1.5 seconds where we don't know why the defendant looked down, if he did look, assuming he did look down for 1.5 seconds, I don't know that that's the purpose of the statute. And I don't believe it survives a motion for required finding because there's two equal propositions. He could have been moving.
Let me interject the question and ask it this way. If the jury heard that the conditions were not hazardous and that the vehicle was in working order and that the defendant admitted that he had looked away or looked down at something, whatever that thing was, and then was suddenly upon the victim, why couldn't the jury reasonably conclude that that action of looking away was negligent and caused the impact?
Again, I think it makes a difference. If a bee flew into his car and he looked down because he had been stung in the leg, is that reasonable that he looked down and swatted the bee away versus texting? I think it matters why somebody looks down. Otherwise, there's no case that I was able to find where a defendant wasn't speeding or drinking or fishtailing or driving under the speed limit or anything, just doing nothing, literally looked down for a second in time and didn't stop on time, and they were found guilty of motor vehicle homicide.
Would it have been okay if it wasn't a bee but he was moving some clothes in the passenger seat.
I think arguably the emergency situation that he created, it would have been to his creation versus a bee coming in, unless someone argued that his window shouldn't have been open. And again, he said it was possible. He didn't know whether he was trying to think of things, obviously some reason why he could have been looking down, but he wasn't sure that it was closed. So where there was no evidence that it was closed, I don't think the Commonwealth, I don't think the jurors could assume that it was. So
He suggested that it might have been closed, right? That was his.
He said it was possible. It was possible. His jacket was off. He said he wasn't taking off his jacket. It was possible that he could have pushed clothes to the side, but he didn't know. A possibility is not enough to survive a required finding of not guilty. It's not beyond a reasonable doubt. So I think it absolutely makes a difference why he looked down, because there needs to be some conduct that is negligent, and human beings who react when they hear a noise or see something and it's spontaneous, I don't think should be punishable criminally. I mean, the defendant here did everything right. Even the DA said that in the sentencing. He felt horrible. He got out of the car immediately, stopped, held victim's arm, head in his arms, called 911. It still bothers him to this day. But is he a criminal? I think that is our argument.
Who said he did everything? Who said he did everything right?
The DA in the sentencing said we couldn't. He didn't feel the 1.5 seconds was right, but he said this is the defendant that did everything. We couldn't have asked for him to do anything more. And I'm paraphrasing. After the accident. Yes, and arguably during, he wasn't speeding, he wasn't drinking, he wasn't on drugs, he wasn't drag racing, he was coming home from work and abiding by all the traffic laws, and a 1.5 seconds. Like again, there is no case that I have found with these circumstances where the defendant hasn't done something that you can point a finger at and say that this is careless, this is negligent, this is reckless.
It's not reckless, negligent homicide.
I understand. Negligent. I haven't found a case, so this would be the first. And I'll rest on my brief unless there are any additional questions.
I see none. A sad case for all the families and people involved. Obviously, we will hear now from Ms. Sherman.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking this court to affirm the defendant's conviction. If I may, I'd like to begin by clarifying the calculations alluded to by defense counsel related to the sufficiency of the evidence for negligence. In the light most favorable to the Commonwealth, the victim was visible to the defendant for 5 seconds as she crossed from the median strip to the other side of Summer Street. The defendant did not press the brakes on his car until 0.005 seconds before he hit Miss Page. Considering the light most favorable to the Commonwealth, the reaction and perception time needed to press the brakes is 1.5 seconds. So that means 3.5 seconds passed, during which the victim was visible to him as he drove straight down a well-lit highway with no obstructions, while he and his car were both of sound health. There are 3.5 seconds, and that's what we're dealing with. The 1.5 second calculation embraced by the defense assumes that his car was stopped in time to not collide with Miss Page, which is not obviously what happened here. And during those 3.5 seconds, it doesn't matter what he was doing necessarily when the jury considers whether or not this rises to the level of negligence. As was the theme throughout the Commonwealth's closing argument, for example, this boils down to the jury assessing that amount of time, the conditions of the road, the defendant's admissions, the expert's calculations, and assessing whether or not he drove in a negligent manner in a way that might endanger the public as he was on Summer Street. And as the jury found, that he was negligent, this court, in considering the evidence in the light most favorable to the Commonwealth, ought not disturb the judge's ruling with the directed verdict or the judge's word.
Can I ask about a couple of the instructions?
Yes.
I'm sorry, a couple of the statements. Well, first about the instructions.
Yes.
The judge instructed, it is not a defense to a motor vehicle homicide that Barbara Page may have been negligent as well, unless her negligence was the sole cause of the fatal collision. That sounds like a correct statement of the law.
That is correct.
But the next statement, that is to say, you may only consider Barbara Page's negligence, if any, if you believe that Robert HAJJAR was not negligent at all and Barbara Page's negligence alone caused her death.
And though the wording there is,
it's not that it's confusing, it's wrong, isn't it? The question is, it's only if his negligence did not cause her death, only hers did. But he could have been negligent, but not caused her death, right? So he's driving along and he does something negligent, but it has no consequence. The only thing that causes the death is the negligence of Ms. Page. And this seems to say that you have to find that he didn't do anything negligent. Not that his negligence didn't cause. It says you have to find that he is, whatever the phrase was, not negligent at all.
and
Am I confusing you? I'm sorry.
no, that I'm trying to keep all the phrasing in my mind. Part of the judge's intention there may have been keeping in mind the stipulation that the collision caused Ms. Page's death. So with that stipulation in mind, and the sole issue at trial being whether or not the defendant's driving rose to the level of criminal negligence for motor vehicle homicide, I believe that instruction does correctly state the law in terms of how the jury ought to consider their verdict, since it rose and fell on that one
only
element.
if causation is somehow built into the concept of negligence, right? You have to find he's not negligent at all. Let's say he was negligent, but he recovered in time, and if she hadn't, solely because she ran across the street at night in the dark, whatever, that's what caused the collision. His negligence didn't. That second sentence suggests you can't consider that because he was negligent.
And though I know you said that it is not confusing, it is wrong. I think it is just confusing in terms of the concept of contributory negligence in motor vehicle homicide cases, that the negligence of the victim has no bearing on the verdict unless it is the sole and exclusive cause.
I agree with that. That's clearly true. That is his own negligence, even if it wouldn't have caused the accident, but for her contributory negligence. He's still responsible for controlling his vehicle to protect from her negligence.
Yes.
He has to do everything he can to properly drive the car to the point where he has to be non-negligent. And then if her negligence causes her death, then it's not on him. That's clearly what the law envisions. This just seems to suggest, and maybe I'm reading, slicing this too thin, I don't know, but it seems to say that he has to have been not negligent at all. And it seems to be someone could be negligent that is not paying adequate attention, not cause the death, you know what I mean, at all, but be negligent, 8 seconds before the collision. But that's not really what caused the accident at all. But again, maybe I am reading this too far.
I believe we're reading it in isolation, which is problematic in terms of not including the judge's instructions on the element of negligence and what the legal concept of negligence is in this context, and how the definition of negligence in a motor vehicle homicide is different than then
Merely not taking due care.
correct. Because I believe, and if I remember correctly, the jury instruction on what negligence is in this concept is in depth and is clear about the level of care that's required and the standard to which the Commonwealth is held to prove negligence. It's not really the layperson concept of whether or not he was negligent. It's whether he was negligent to the point that he put lives in danger. And if he was negligent to that point, if the jury considered him negligent in any way to that extent, then as they did, her instruction, I believe, is correct about how they ought to consider that in relation to any negligence on behalf of the victim.
Ms. Sherman, rather, would you agree that that second sentence appeared to be the judge's sort of impromptu elaboration on the first sentence, which was an accurate construction of the law?
I believe it was, and if I remember the record correctly, these instructions were given after, they were given by request of the parties after she had finished her complete instructions. I think they had conferred about it before jury instructions. She said she was going to be giving this contributory negligence instruction, and then did not. So they had to bring it to her attention and made specific requests about it in light of the way that they had closed and prefaced her instructions to the jury. So I do think that was an addition that she added, not one that had been discussed beforehand. If there are no further questions about the jury instructions or the sufficiency of the evidence, I'll turn towards the closing argument. The prosecutor in this case made no errors during his closing argument. He used rhetoric appropriately and effectively to ask the jury to consider the evidence in this case in light of their common sense and life experience. He did that through the use of hypotheticals and rhetoricals that embraced the evidence before the jury and also worked to contrast the evidence with the way that it had been presented by defense counsel in closing.
Anything you'd like to say, Ms. Sherman, on the first issue? That is the citation.
I will say only that that motor vehicle homicide, Chapter 90, Section 24G, is explicitly exempt from the remedy of dismissal for the failure to issue a citation. And based on the questions posed to sister counsel, I believe the court understands the Commonwealth's position on that issue.
And what, if anything, is your position on whether or not the footnote in the Cameron case would require the issuance of a citation at some point in time?
Because he was indicted and because the failure to issue him a citation does not frustrate the purposes of the no-fix statute of Chapter 90C, Section 2, I don't believe that would have any bearing on this case. As your honors have noted, the defendant was on notice of the severity of the harm to the victim in this case, the investigation that was ongoing, and the issuance of a paper to him notifying him of that would not have served any additional notification purposes.
The delay between the collision and the indictment is a little out of the ordinary. Is there anything in the record that would inform us as to the reason for that?
I don't believe there is anything contained in the record that would explain that. There was no transcript of the motion to dismiss argument. And I can't recall if the parties' memos had additional facts in them, but the accident reconstruction process is a lengthy one. And I think that often dictates the timeline. If there are no further questions, I will rest on my brief.
See none. Excellent argument from each of you. And again, it's a difficult and sad case for all the people involved. So thank you very much. Very helpful argument.
Live and on the record.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I and you are joined today by my colleagues, Justice Kinder and Justice Desmond. The next case we will be hearing is number 20-458, Executive Office of Health and Human Services versus Cynthia TROCKI. The rules of argument are the same as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. As per the court's prior order, the appellant's time has been divided so that appellant will have the first 10 minutes of argument, and then amici, the Massachusetts Law Reform Institute, and others will have 5 minutes of argument. And should any of that go long, Attorney Fisher-Grobin, you can be assured that you will get additional time as well, although perhaps we will keep this to 15 minutes aside, depending on how the argument goes. We will hear first on behalf of Ms. TROCKI from Attorney Vanderlinden.
Good morning. May it please the court. My name is Charles Vanderlinden. I represent Cynthia TROCKI, who is serving as the personal representative of the estate of her father, Stephen Pacala. There are really just 3 issues that I want to touch on, although others are covered in the brief. First, the exact circumstances in which Mr. Pacala found himself in 2013. Second, the fact that he was not provided with the separate notice that he should have received concerning the consequences of participating in what is referred to as a SCO. And third, the fact that the Commonwealth is not authorized by statute to recover the full amount of a capitation payment. They are limited to the actual cost of medical care and services. So on the first of those issues, Stephen Pacala was 78 years old in 2013. He had been on Medicare since he turned 65. And in the fall of 2013, he also enrolled in an additional program. It was referred to as the Fallon Senior Plan, HMO. Once he had done that, virtually all of his medical costs were covered. He had the foundational Medicare, and now he had Fallon Senior Care Plan, HMO. He was advised, however, that there might be some additional copays or deductibles. And because he was what was referred to as dual eligible, that is, he's eligible to participate in Medicare by virtue of age, and he was eligible for Medicaid assistance by virtue of income, that he ought to apply for an additional program, what's called a senior care option or a senior care organization, a SCO. He did that. He looked at the application with his daughter, as her affidavit, which is in the record, indicates. They went through that application and he annotated it. He said he was willing to participate in that program, but it was with the understanding that his estate would only be liable for some further state recovery if he was in a nursing home. He specifically included a note to that effect in the application form itself, and said just nursing home expenses. Discovery was not completed at the time summary judgment was granted. We have no acknowledgement by the Commonwealth as to how that application form was handled. But the basic information is he was prepared to participate in this additional program. He had virtually no uncovered medical expenses, but if he was going to do so, it was with the understanding he wasn't going to create obligations for his estate.
So for purposes of the summary judgment record, we presume that the executive office received that application. There's some dispute in the record as to whether or not they actually received it. Is that right?
Yes, at the status that things were at the time summary judgment was heard, their responses to discovery so far had been that they did not have knowledge as to whether they received it. There's no indication they didn't. And Ms. TROCKI's affidavit indicates that that's the exact application they submitted. The second issue is the failure to provide separate notice. So this was a type of program that was different from what most citizens in the Commonwealth are aware of in terms of Medicaid. This was a SCO. And the Medicaid manual, the state Medicaid manual that was in effect at the time, had a very specific requirement. It said to the state, you must provide separate notice to the beneficiary that explains that the premium payments to the managed care organization are going to be included either in whole or in part in a claim against your estate. I would suggest that if you read that application form, first of all, there's no separate notice. There's not some separate document that says warning or disclosure or something of that nature. It is in fact a very opaque statement as to how estate recovery might work. There's no reference to payments to a managed care organization. There's no reference to capitation payments. And this is in a setting where we have dual eligible citizens. They are elderly and they have limited income. So those notices ought to be looked at very carefully as to whether they enabled Mr. Piccola to make an informed judgment about how he wished to proceed.
Can I ask you two questions?
Yes.
First of all, in a regular mass health situation, not an SCO, are the enrollees sent something that indicates to them how much has been spent each month or each quarter or something, so that if they realize that they are running the risk that there will be a big claim against their estate, they can decide to withdraw? Do we know anything about that? Are there regs or anything? And it may be that your sister may know more about this than you because she's from the executive office, but do you know the answer to that question?
I do not know the answer to that.
Okay, and I said I had a second question, so I guess I could make one up. I did have a second question. I'll think of it. You can keep going.
Well, the short argument on the notice is that there was simply not adequate notice. There's no reference to the capitation payments. And Mr. Piccola literally had no idea. When we stand here today, we now see a claim that shows that instantaneously after he signed up for this program, there were claims against his estate that the Commonwealth is now trying to advance that were running up at.
I know what I was going to ask you. Why is he able to get mass health when he has a house? The answer to that?
Pardon?
Do you know the answer to that?
I believe the answer is there are certain rules about income and certain rules about assets, and having a residence, especially one where he's residing, there is a provision that says you can have a residence and still be eligible.
Only for elderly people, or your residence is always excluded from the? I thought you had to have under $2,000 in assets before you could be eligible for mass health. But that may be in some categories or something.
I think liquid assets has that kind of cap. But
you can have a house, you have an $8 million house, and it doesn't count as an asset.
I'm not sure about the $8 million house.
All right, well, again, your sister may know where the caps lie, but all right.
You indicated that the executive office isn't entitled to the full recovery. So is there a figure that's actual in dispute? How much are they entitled to?
We're at a stage in this litigation where we don't know what the actual costs of medical care and services provided to Mr. Piccola were. There was, the claim they've made is for the $179,000, starting off at $3,200 and $49 a month to begin with, and then ending at $2,750 a month in 2018. We don't know. He remained in his home, living independently. All of the indications from what's in the record is the affidavit of his daughter that he had very limited usage of medical care or expense. But the truth is, we honestly don't know what that number is until we have further discovery. So the third issue that I wanted to mention briefly is the issue about the limits on what the Commonwealth can recover for. The state statute provides that the Commonwealth can recover for medical assistance. And first of all, This is an exception. Both the state statute and the federal statute, which are cited in the brief, start out with the phrase that says, there shall be no adjustment or recovery except, and then there are certain exceptions. And one of the exceptions, the one that's applicable here, is for the cost of medical care and services provided to recipients. Medical assistance is defined, and it doesn't include any reference to capitation payments. It simply says it's defined as the cost of medical care and services provided to recipients. Capitation is defined. It's a defined term. The legislature found its way to include that definition in a different part of the statute. It never amended the description of medical assistance for which recovery is possible to include any reference to capitation payments. So again, the setting inside of this statute is that this is an exception. And as other cases in this area, most notably the Anderson case from the SJC, because we're dealing with an exception, it ought to be narrowly construed. Our argument is simply that in the setting where estate recovery is the exception, there's no reference to capitation payments being recoverable, that the Commonwealth is limited to only recovering the cost of medical care and services. And that's not what the Superior Court allowed. They allowed the entire capitation payment to be recovered.
Okay, your time has expired. Many interesting issues here that we will continue to explore with counsel, starting next with Attorney Poulos.
Thank you, Your Honor. I'm here representing the amici, but really here to speak for tens of thousands of low-income elderly mass health members who are in the same position that Mr. Pacala found themselves in. Had they remained in the traditional Medicaid fee-for-service system, there is no question that the state could only recover the medical expenses they actually paid for them, that they actually received, and could not recover what's called the Medicare cost sharing, the portion of their Medicare out-of-pocket costs, which they would have to pay themselves if they were uninsured, but which Medicaid pays for them as Medicaid recipients. However, because they made the choice to enroll in a SCO, and it is a choice, it is strictly voluntary for these people who have both Medicaid and mass health, the state takes the position that as soon as they made that choice to enroll in the SCO, they began incurring an expense of thousands of dollars for each and every month that they would not have owed had they simply remained in the traditional Medicaid fee-for-service system, and that the state had no obligation to tell them that when they made the choice.
Do you know whether fee-for-service mass health members whose estates are subject to recovery in certain circumstances, do you know if they receive some kind of a statement of benefits that indicates what has been spent on them?
They do not. There's nothing like that as there is commonly in private insurance and Medicare. What they do know, though, is I went to the hospital. I had a home health aide come to my house. I filled a prescription. They know they're getting medical assistance and have some idea of what the value is. Whereas in a SCO, as the state explicitly says, someone could be receiving no medical assistance whatsoever, and they would still incur this debt, and they have no way to know the amount of the debt.
And is there no provision for separate notice in a non-capitated system? Is the notice that's given, this half sentence or whatever that says something like, we may get money back from your estate, or whatever it says, is that all that's required?
The extent of notice of the basic notice of Medicaid estate recovery is really not spelled out. The appellants argue in their argument that it has to be adequate notice within the meaning of the
of course,
and that this is not adequate notice. Clearly, Mr. Pacala did not understand it. He thought it just
applied in this case, but I'm asking more broadly, right? Even fee-for-service people may have something, money taken from them without knowing it. Are there no cases about what the due process requirements are before you begin giving someone a benefit that's eating away at their estate?
It is stunning how little developed case law there is interpreting the scope of Medicaid estate recovery and Medicaid managed care, but generally estate recovery in this context. So none of the parties have cited a case to that effect. I would.
Doesn't the fact that he annotated a particular portion of the application suggest that he had notice?
He certainly knew there was such a thing as estate recovery. From his annotation, it's clear he thought it applied only to nursing home care, which I think most people would read that sentence and draw that conclusion. The only express cost it referred to as nursing home care. And that's what the SCO told him. And the very absence of information from the agency really leaves Medicaid recipients open to misinformation from the SCOs. He's exactly the kind of person the SCO wants to provide. He has a lot of pre-existing conditions. They know that, they insured him before, but he doesn't use a lot of medical services. As a result, they're going to be paid this extraordinarily high capitation rate.
And I take it, well, I don't know if Amiki has a position on this. If they didn't like it, Mass Health shouldn't have approved the thing. If his changes were unacceptable to them, they shouldn't have put him in the SCO. They should have said, no, we don't accept your suggested changes to the agreement.
Now, that was just his basic application for medical assistance. And that statement was their disclosure, which was not adequate, and he obviously did not understand it.
But I'm saying he wrote something else in and sent it back, yes. He says, right? Or Ms. Trocchi says. Okay.
Yes. I'm sorry.
You've only had 5 minutes, but I think we understand your arguments. And of course, we also have your brief. We will hear now from Attorney Fisher-Groban.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court, Phoebe Fisher-Groban on behalf of the Executive Office of Health and Human Services, which I'll refer to as EOHHS because it's easier. The Superior Court in this case correctly granted summary judgment for EOHHS on its estate recovery claim because estate recovery is required by state law in this case. And there's no federal or state requirement for different notice from what Mr. Pacala received in this case.
All right, well, can we start with the first argument that your brother has made? There is some kind of an application form. I understand if you're saying, look, our state statute says we have to recover, so it's nice that you wrote nursing home only on this, but that's not an option. It's whatever the statute says. But are you saying that this is a contract? How would I put this? Assuming you received his application with these changes on it, wasn't it incumbent on you to reject it rather than start giving him something that he clearly was trying to avoid through bargaining?
No, Your Honor. This is an application for Mass Health benefits. It's not a contract between private parties. And the appellant hasn't cited any case law suggesting that it is. And even if these—
Well, why do you ask for something back from him? I don't understand.
Well,
people don't have to apply for Mass Health, right?
No, that's certainly correct. And Your Honor, in this case, Mr. Pacala submitted this application. And again, there is a dispute of fact as to whether Mass Health received it, but for purposes of summary judgment, we presume that they did.
All right, so if you received it and he said he didn't agree to the terms, shouldn't you have said, thanks, we're not, yeah, we reject your application. The terms are what we wrote in this thing, not this stuff you wrote in.
Well, in this case, there's the 2013 application, and
I mean, if you're going to say that then sometime later, it also said it on another form, you had it for summary judgment purposes, you have this application. Why didn't you write back to him right then and say, we reject your application?
Because he was eligible for Mass Health and he submitted an application for Mass Health benefits.
He changed it.
The changes on the application are not binding. This is an
Okay, but then
application.
the application itself isn't binding either, is it?
Well,
He did not sign the application you sent him. He changed it.
He made notations on the application and submitted to Mass Health, and then began to receive medical assistance.
Because you approved the application.
Yes, Mass Health approved
Why did
the
you approve an application that didn't include the terms you needed?
Because it's an application for benefits, and he met the eligibility criteria for Mass Health. It wasn't a contract between Mr. Pacala and Mass Health. And then he subsequently submitted.
Well, it was something, right? You say it wasn't a contract, but he didn't have to apply, and he did, and you agreed to give him the benefits. You evaluated him for eligibility. How did you do that?
Well, that's correct, because he was eligible for
Okay,
Mass
so
Health.
on the application, it has a place to put what your assets are and so on?
As part of the application, yes, he had.
Okay, and that has to be true, what he writes down, and you have to read it to figure out if it's okay or not. Why don't you have to read the places he crossed out?
Well, he actually didn't cross out any portions of the application.
Okay, well, why don't you have to read the places he inserted additional text?
Because it's not a negotiation between parties over the
How's he supposed to know that?
Because it's an application for benefits, and the criteria for whether he's entitled to benefits are set by EOHHS.
Yes, I understand. So you shouldn't have been giving them to him. He said he wouldn't pay except for nursing home care out of his estate. That's not an option, right?
Well, state law requires a state recovery from.
Only if you agree to accept his application.
Your Honor, the appellant has cited no case law for the notion that an application for public benefits is akin to a binding contract where.
It seems like you're saying he's bound. You are saying he's bound, right? He's given you access to his estate. You don't call that a contract? What would you call it?
I would call this an application for benefits, but what permits the state in this case to recover from his estate is state law.
But if he had committed fraud and wrote a number in that was false, you'd be going after, well, you're going after him for everything anyway, but there'd be punishments, there'd be, right? He has to write something true on this thing and send it to you. And you evaluate it and decide if he's entitled or not. I'm just trying to figure out why summary judgment on that point. But I mean, I get that government agencies don't like doing work, don't like looking at individual people's changes on documents, but we have rules about contracts of adhesion and so on. Seems to me that this is, I mean, it's unbelievable. There's an actual person who read this closely enough and thought, wow, this is a little ambiguous. I'll clarify it with these words here and send it back to them. And the answer is, sorry, we approved your application. We read all the parts that we cared about, but not the part you cared about. Seems odd to me.
Well, the application here, it's simply not, if you look at the application, it's simply not a contract between Mass Health and the recipient. It's an application where the potential enrollee says to Mass Health, I am eligible for Mass Health. And then if I'm found to be eligible, I give permission for these things. And then there's this notice in this application that clearly and in pretty easy to read language tells the applicant that a state recovery may apply in their case.
May apply.
Pardon me?
May apply, I don't know. And then it says something about for nursing home eligible or something, people, right? It says something about nursing homes, right in that sentence.
The notice here is quite clear. It says, I understand that if I am aged 55 or older, or I am any age and Mass Health helps pay for my care in a nursing home, Mass Health may be able to get back money from my estate after I die. So it clearly provides two options. If the applicant is 55 or older, or if the applicant is in a nursing home. And in this case, neither federal nor state law require additional notice. This is actual notice.
Okay, so let's talk about that. The Medicaid manual says there has to be a separate sheet of paper with a capitation plan saying whether all or some will be collected from the estate. And you don't provide that, or didn't provide it. I don't know if you do now, but you didn't at this time at least provide that. That is not binding, although sometimes we hear from you guys how we have to look at the Medicaid manual because that's really the thing. But in this case, it's not binding. Okay, that sounds like accurate law. Why isn't it a persuasive construction of federal law?
It's not a persuasive construction of federal law for two reasons. The first is we have state law here that requires estate recovery in this case. In other words, EOHHS.
Yeah, but this is about the notice. This is a question of what notice is required before you can implement that. And you're only allowed to implement that because the federal government lets you. Right? You're allowed, you don't have to, and the state Commonwealth is allowed to collect, but doesn't have to. And the Commonwealth has chosen to. Why don't you also have to follow the notice requirement in the manual?
Well, because it's not binding, and it doesn't persuade here because, again, state law requires that EOHHS collect in this case.
State law doesn't say don't give any notice.
That's absolutely right. And that is why EOHHS does give notice here. In other words, there is a clear, easy to read notice in this application. This is actual notice that is given to an applicant and then is repeated in the eligibility review form. And this says that if they are above age 55, that EOHHS may seek to recover from their estate. So this is notice that's, it's reasonable and it's reasonably calculated to provide notice to the applicant about the estate recovery process. And it's more than adequate. In fact, it's broader than
more than adequate notice to put in this thing. We may go after your estate. Wouldn't someone want to know how much that's going to be? I mean, I understand not even the manual says that. If it were you, wouldn't you want to know whether we're talking about your whole house or $80? May go after your estate?
Well, there are exceptions, none of which apply here to estate recovery. So it is a may. In other words, there are exceptions that may apply to whether estate recovery is applicable. And it also depends on whether the applicant has an estate that goes through the probate process.
I see also that non-nursing home eligible people pay like $100, $200 a month, but nursing home eligible people pay $3,000 or $4,000 a month. How can it be that you're allowed to not tell them what within orders of magnitude what they're subjecting themselves to? Well, I mean, it's their house. Now, if you say, and I could see saying this, listen, you're saying mass health. So you're saying you're poor, but apparently you're allowed to keep your house. I don't know. Maybe you can tell me how that works. I was not aware that you could keep your house and still be mass health eligible, but you get to keep your house. But listen, we're taking it at the end. That's what we're saying. All you're being left with is you can use it during your life because we're being nice to you, but we don't give away free money. And your house that we're not going to count toward your eligibility will ultimately be counted toward your eligibility. We'll take it away. That seems like a very reasonable piece of notice to give someone. But I just don't understand. I don't understand how you're supposed to decide whether to sign up or not for something with literally no idea. And in some cases, it's $100 a month, and in some cases, it's $3,000.
Well, Your Honor, respectfully, there are two answers to this question. The first is, what is adequate notice and what does due process require? And respectfully, due process requires actual notice of the potential of estate recovery, which is precisely what this notice provides. And neither amici nor the appellant have cited any case law, particularly case law in the context of property and deprivation of property, suggesting that this notice is insufficient or inadequate. And secondly, at the time that an applicant enrolls in Mass Health, it's unknown how much the state may seek to recover from their estate, and the details of their estate are similarly unknown. And so it would be impossible to provide more specifics on this general Mass Health form. But this Mass Health form does say, as does the eligibility.
Well, you could, you know what the current premium is going to be on the SCO. You could certainly say, same as mortgage lenders do or whatever, they change the form for every person based on that day's interest rate. You could say the current premium of your SCO is $3,000 a month. And we'll be recovering all of this, even if you get no medical care from your estate. Now you may decide if you want to join or not.
Your Honor, this is an application for mass health. And so this just generally lets the applicant know about the potential for a state recovery. This is not a notice that is specific to the managed care organizations, and it just lets someone know about the potential for a state recovery.
Is that why there is a special rule in the manual, do you think, for capitated plans?
Your Honor, I don't know why there is a special provision in the Medicaid manual for capitated plans, but I do know that the state Medicaid manual is not binding here, but state law requiring a state recovery under these circumstances is. And neither amici nor the appellant have cited, again, any authority, and EOHHS is aware of none, where a state recovery, which is mandatory on under state law, is precluded by notice, particularly a notice provision in a state Medicaid manual, which is sub-regulatory guidance, and it's not binding on this court.
Do you think the process is just fundamentally fair? Do you think it's fair?
Well, this process is fair because adequate notice is provided to the applicant when they receive this application. It's notice that informs the applicant that when they sign up for mass health, that their estate may be subject to a claim for a state recovery. And you know, in this case, the factual allegations are that Mr. Pacala didn't use services, but there are certainly situations where senior use services far in excess of what EOHHS pays on their behalf. And in that situation, the amount that can be recovered from their estate, and in this case, again, to answer Justice Rubin's question, although an applicant's income and assets may be below the requirement, the way the statutory framework is you get to remain in your home for your lifetime. EOHHS will not seek to recover from your house, and you don't need to sell it.
And your house doesn't affect your eligibility for mass health? Is that true?
That's correct. So in other words,
a house of any value.
I believe that that's correct, that you are in, because the notion is that you shouldn't have to sell your house to be able to afford medical care, so long as as in this case, your income and your other kind of assets are below the requirement. But for many seniors, the capitation payments is well below the enormous amount of services that they receive. And so it is fair. Your Honor, I see that my time
has expired. Are there other questions, though? Okay, I see none. It's a complicated case. I hope I haven't been too hard on you, Attorney Fisher-Rubin. I'm troubled by some of how this went. Not the argument, but for the decedent here. But there we are. Thank you very much all for your arguments. They're very helpful. This turns us on and recording, and then
live and on the record.
Good morning. Welcome to the Appeals Court.
Thank you.
I'm Judge Rubin. I'm joined today by Justice Kinder and Justice Desmond. The next case we'll be hearing is BZ versus XW, number 20-34. This is a partially impounded case, so I'll just remind you not to use the full names of the parties and to adhere to any other aspect of impoundment with which you, I'm sure, are familiar. We will hear from counsel for the appellant, Attorney Corey.
Okay, very good. Thank you so much. I really appreciate this opportunity. I want to preface the legal portion of my argument with a little bit of perspective and reality. 2 points to be made. The first is that obviously a restraining order can be a very good thing. It is a shield that can protect somebody who is afraid of harm from somebody else. But by the same token, that tool can also be used as a club, as a weapon against somebody else, especially in the context of an acrimonious divorce and custody case. The second point I want to make is that the reality is it's not just women who are victims of domestic violence. Men are too. With that in mind, let's move on to the legal aspects of this case. I want to start with the district court denying the defendant's motion for reconsideration. So there were two reasons why the district court was flat out wrong in denying this motion to reconsider, particularly without a hearing. The first is that the defendant presented the district court with an abundance of evidence that plaintiff was committing a fraud on the court. He provided the district court with an abundance of evidence that it was he was the victim of domestic violence in
Why
this.
can't they both be victims of domestic violence?
There could be mutual violence, Judge, but he had solid evidence, photos, sworn testimony, affidavits. There was a transcript from a subsequent magistrate.
Ms. Corey, can I ask you a question about that?
Of course.
The original hearing and the extension hearing dealt with an event that occurred on March 6th of 2019. What was submitted in connection with the motion to reconsider was an affidavit, voluminous written material that related not just to what happened on that day, but a pattern of parenting conduct and other incidents on other dates preceding what occurred and perhaps after, I can't recall. I think there's a question as to whether or not much of that material would even have been relevant as to the judge's decision regarding what happened on March 6th.
In response to that, Judge, it's highly relevant in the context of the plaintiff committing a fraud on the court. A fraud on the court, and this is this should be disturbing. A fraud on the court, as we all know, is a calculated plan to deceive the court, a calculated plan to feed the court false information or withhold from the court false information in order to get what you want. Now, defendant's later submission in his motion to reconsider all of those previous instances where he was the victim of abuse at her hands is highly relevant to her calculated plan to deceive the court into believing that she was the victim on that particular day.
Typically, Ms. Corey, on the appeals court, we defer to judges of credibility made by trial court judges because they're in a better position than we are to judge the credibility of the complainant in this case and the defendant. Why shouldn't we rely on that basic deference here?
For the very second reason that the district court was wrong in denying the motion for reconsideration without a hearing, and that is because the defendant did not know what was being said at the initial hearing. In his motion for reconsideration, besides providing ample evidence that she was deceiving the court, he provided ample evidence that he just did not understand what was going on, so we can get into this, the translation. The defendant was not given an accurate translation or a literal translation. And this became apparent to him only later when family members read to him the transcript of what took place at the hearing. It's like he must have fallen off his chair because this is not what he had understood took place. So in his motion to reconsider, he specifically told the judge, he says, I had difficulty completely understanding translators' Chinese, and I had to guess at the approximate meanings. He also said, the judge said what I felt to be a lot, but what the translator conveyed to me seemed to be much briefer. So this reminds me of a funny scene from the movie Lost in Translation, where Bill Murray is a famous American actor who goes to Japan to film a commercial. On the set, the Japanese director is giving him his instructions. Da, 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 da. And so Bill Murray turns to the translator and she says, he said to smile. Like, that's funny in a movie, but it's not funny in a courtroom.
What specifically did he miss?
What specific? It's detailed, more detailed in his motion, but
I didn't see any real detail about this. I mean, I saw what he said, but I didn't see that he said, I didn't understand that whatever it was that she was saying I had grabbed her, or that or that this could result in a restraining order, or I'm not sure what it is. I mean, doesn't he have to make a showing of exactly what it is he's talking about?
Well, this is why
the interpreter said to me X, but in fact, the judge said Y or whatever.
Your Honor, this is exactly why this court has issued opinion saying when a motion to reconsider is presented with fresh material, one of the cases says, or important new information that was not before the judge at the initial hearing, the better practice is to hold a hearing. This is why the district court should have held a hearing.
No, I don't necessarily see that. It seems to me that the person filing the affidavit should be concrete about what the issue is. If he fell off his chair when someone read the transcript to him, presumably he could say, no, she said, the translator said to me, you've done nothing wrong. But here she seems to have been, the English seems to have been the opposite, or, something. How are we supposed to, it just seemed a little non-specific to me to say it's an abuse of discretion to deny, on that ground at least, the motion for reconsideration.
When a person does not speak English, they are entitled to a literal translation. Even, okay, perhaps there could have been something more specific, but frankly, that could have been hashed out at a hearing on the motion. But he did say specifically in his affidavit that throughout the hearing, he had to guess at what was going on. And the translation was so poor, Judge, that a couple months later, he brought his own translator with him to a magistrate's hearing, just because he was afraid that he wouldn't understand again.
I mean, we've seen problems with translators. Occasionally you'll get, you'll actually even be able to see, because you'll have the Spanish and English next to each other, and there you see issues with this all the time. But it seems to me it has to be presented in a way that shows what its bearing was on the proceeding.
I think that the transcript of the initial hearing itself points to or corroborates or shows that he was utterly confused. At the end of the hearing, he didn't even realize that the judge had extended the order. That is the level of confusion that he was in at the initial hearing. The better practice.
I'm looking here at a page of the transcript from the hearing, and the judge allows your client to read from his prepared statement, and it says, I don't feel like I abused my wife. Yesterday we were fighting. She grabbed onto my collar. I was very scared. It goes on to say that she's assaulted him in the past. So that's why I subconsciously pushed her to the sofa.
Mm-hmm.
So it seems like at least some of what was being complained about by the complainant was conceded, at least that there was a fight and that he had pushed her onto the sofa. It didn't seem like there was any confusion about that allegation.
Well, he, you see in his affidavit, she grabbed onto his collar, which is consistent with her prior abusive behavior.
Yes, if the
And
judge
he was-
believed it.
But the judge didn't have any of this information
Well,
about
his testimony.
But the judge did not have the information that was included with his motion to
He
reconsider.
told her she's assaulted me a number of times.
And is that really going to be believable for a man without establishing a pattern of abuse for a man to go, you know?
And so it has to be, once you introduce these photos months later, you have to undo the order. You have to now believe the husband because in fact he was defending himself on that day because in fact he was. The judge must have looked at the pictures, right?
I hope so, but I really don't know.
Well, I don't know either, but I hope so. I've looked at them, so, I hope the judge did, right? And the judge didn't allow it. The judge wasn't compelled by the photos to believe it was self-defense on that day, was she?
Again, I think it's an abuse of discretion not to have a hearing when presented with this level of significant evidence. I mean, what more could he have given the district court? And this is not a rhetorical question. I'm serious. What more could he have done to get a hearing?
The judge still gets to judge the credibility of the witnesses. He gave her everything. That doesn't actually mean that he was acting in self-defense within whatever the narrow scope is, duties to retreat and so on, right? We don't know enough about, right? He may have given her all he had, but she's still allowed to believe, and we can't do anything about it, the woman.
You can remand for a hearing on the motion to reconsider, which would be the better practice, given this level of information that he was able to bring to the court. I mean, what does it take to get a hearing on this? I can't see what more he could have done.
Assuming she had a history of bad behavior,
Mm-hmm.
Does that mean she wasn't frightened and afraid on this particular day?
That's something that could have been heard and could have been investigated at a hearing. But Judge,
isn't that what he read in his statement? Didn't he say that, she had a history of abuse? What is it? What does his statement say? Isn't that what his statement said at the day of the hearing?
that she had abused, yes, but he was at a complete disadvantage with the language barrier. He was in no position to give a reasoned. He didn't know what was going on. I can't stress that enough. To be in a court proceeding where you can't understand the language and where you have to guess at what is being said because the translation is so bad, that is just not right. That's not fair, and that's not what our rules call for.
Can I ask you one technical question because your time is very short? There is no notice of appeal from the original extension order, is that right?
Notice of appeal, yes. The notice of appeal was from the extension and from the denial of the motion to reconsider. It should be in.
Well, I don't understand what entitlement you have to file that late of a notice of appeal from the extension. It wasn't timely, right?
I would have to check. I'm sorry, but
okay, well,
at a minimum,
check the dates.
At a minimum, you could remand for an actual hearing on this issue. Please do so.
Okay, your time has expired. I think we understand your arguments. Very well put on behalf of your client. Thank you.
We're live and on the record.
Good afternoon. Welcome to the Appeals Court. I'm Judge Rubin. I am joined by my colleagues, Judge Kinder and Judge Desmond. Our last case for today is number 20-1166, Porter versus Board of Appeal of the City of Boston. The rules here for argument are the same as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. And we will hear first from Mr. Porter, who is appearing pro se.
Thank you very much. I would like to start by presenting based on simplicity of the issues. So I'll start with the $25,000 bond. This is an unnecessary hurdle and hardship. The Superior Court judge used a earlier date, had no tangible damages to base it on, and it seems she was pretty rough on me. I'm not an experienced trial lawyer, though. I contend that I have tangible reasons to be before this court, so I would like to see the bond returned to me. My next issue is parking. Based on the parking issues alone, I think this case can be overturned. Their parking expert testified, once I showed him the chart, that this residential property requires 1.75 parking spots per apartment. That times 2 would equal 3.5, which rounds up to 4. I believe they made a mistake using the commercial requirement for parking, and no one caught this mistake. So based on that.
Did you offer any expert testimony at the hearing?
Did I?
Yeah.
No, I did not. So, but
did
their
you have any support for some of the propositions you raised with respect to the parking and the overcrowding, or some of the other issues that you said negatively impacted you as a result of this construction?
I didn't, but their parking expert agreed with me. So merely on that basis alone, they are deficient in the required number.
Yes, but I
spots.
think that what Judge Desmond is getting at is that you have to be injured. You can't just be a roving patrolman saying this house doesn't have enough parking spaces. You have to show how you're actually aggrieved by it, not merely by being in a abutter, but actually aggrieved by it, and the judge found you hadn't made that show.
Again, only through my own testimony that parking is extremely limited. I'm a resident. It's hard for myself and others to get parking on the street. So by adding 4 additional units, you'd end up with 10, potentially 10 people or more that could live in this building. So the requirement is not met. I think you could have a larger effect. And again, they also testified they already have 5+ parking spots on the property.
But how many parking spots will they have after this is done?
They will only have 3.
And you say they need how many?
They need 4.
So 1 more car will park that wouldn't otherwise on the street, right? At most, because even if they have 20 cars, they'd only have 1 more space in the building.
Right, but they're adding residents, they're adding bedrooms. So they're adding bedrooms and not meeting their parking requirement.
I agree, but how does the absence of 1 space, I'm not even sure this was litigated, but how does the absence of 1 space, the judge found that didn't injure you. And there was the other side put forward experts on parking that the judge apparently believed.
I don't know that they, and I could be wrong, they submitted a parking study.
Yeah.
Did they? Yeah. So, yeah. If I'm in the wrong, then I'm in the wrong. I'm just presenting my information. I'm giving my testimony. Parking is a challenge.
Mr. Porter, one of the things
presently illegal? I'm sorry, Justice Kinder.
I was just going to say, one of the other things that Judge Giles apparently relied upon in determining that you didn't have standing was that whatever density or parking concerns you talked about in your testimony were not unique to you as opposed to the other neighbors in the community. Is there anything that's unique to the damage to your property as a result of density and parking issues?
I would like to get to that in regards to standing, yes.
Okay, this would be a good time.
All right, great. So with regards to standing, my brief and reply brief were written prior to the appeal court decision in Porter versus the Zoning Board of Appeals, February of this year, 2021. Based on that case, it would seem that the issue of my standing is now stare decisis. So I don't think I need to discuss my standing. There are two other aspects, which is what you're asking about regarding standing. I'll briefly go into this. My first is that they presented false information. And by presenting false information, I'm suggesting that the larger community should be granted standing. The reason that this developer portrayed it as owner occupied is to qualify as a hardship, as a requirement for granting variance. With court's current position on standing, if developers are presenting false information, no one can hold them accountable because this hurdle of standing is more like a fortress. A case would get dismissed based on a tiny keyhole proximity rather than the substance. This is the issue with standing. It is a hurdle or a fortress that disallows the presentation of information. I'm asking the court to consider that some cases, such as mine, standing is denied based on the proper consideration for cases and the developers are benefiting from it. Now, the unique harm, which is what you asked for, unique harm is required for standing, which I contend is nearly impossible in the city. 300 feet in the city affects hundreds of people, different from the suburbs or rural Massachusetts, where 300 feet might only affect a few people, which gives the rural suburban people an advantage to show unique harm. For example, my tenants and I use the same front door, streets, sidewalks, driveway. Our windows face the same direction. We breathe the same air, and we live, and our living experiences are essentially the same. So it's nearly impossible for me to have a unique harm from my tenants with regards to standing. Because the Boston zoning code is unique from the rest of Massachusetts, and the articles in the zoning code are unique, this gives the court more leeway for consideration on this issue of standing unique harm for the residents of Boston, which is what I'm asking the court to consider. My final issue.
Can I just mention, I just looked at the Porter case from February. I was on that panel, of course, and we didn't find that you had standing. We found that you had presumptive standing from being directly across the street. And in this case, you have presumptive standing from your status as an abutter, but that doesn't necessarily mean that you, at the end of the day, have standing. It's this presumption in the statute.
Understood. Yeah, it seemed.
So it's not stare decisis on anything here.
Okay.
Okay.
Understood. It seemed that what the court was offering is a greater extension of standing. But this is what I'm arguing in this case. Mm-hmm. Is that standing needs to be considered in the city a much broader or wider range. So the last aspect of my case that I would like the court to consider is obviously a very controversial piece. The thought that the Article 51 is a contract. Obviously, I'm not a lawyer, and it makes sense to say, Mr. Porter, you don't understand a contract, which I completely agree with. But I'm asking to consider what is Article 51, which was written to protect the residents of Allston, Brighton. In the late 80s, Mayor Menino divided up the city, spent a number of years with these non-city people writing articles for each neighborhood. Thousands of hours were put forth to create these detailed guidelines. Once complete, it was agreed upon, signed off by everyone, and the mayor enacted it in 1991. We have elements of a contract, an offer, consideration, meeting the minds, and two-party acceptance. In Article 51, Section 6, it even lists the non-city parties that were involved in the creation of this document. So if it's not a contract, if Article 51 is not a contract, is it a social contract, a promise, an agreement? Zoning is often statutes, but the city is not a legislative body. So could it be a contract within the ordinance? This is what I'm asking the court to consider. I feel that Article 51 is more than just an ordinance because it acts as an agreement between two parties and is a written promise between the city and the residents to protect from overdevelopment. It offers general neighborhood guidelines to protect the property and well-being of the residents, not to protect one resident from one unique harm, but all the residents. I bought my houses with the agreement in place, which was maintained by the past administration and updated frequently for 20 years. Currently, it feels like the new administration could change the zoning to fit their desires and massively affect the face of Boston in spite of the promises of the articles for each neighborhood. Not to be overly hyperbolic, but what stops the city from, say, bulldozing the brownstones in Beacon Hill? So, quick summary, the Boston zoning is unique. The articles were executed in a unique manner. Boston is handing out variances without their compliance to 3 or 4 of the required conditions for the variances in their own zoning. And I'm here presenting not just on my behalf, but for the whole of Boston. So I thank you for your generosity and consideration of my arguments.
Thank you very much. I know it's difficult not being a lawyer to appear before us, so we appreciate your thoughts and input. And we will hear now from Attorney Centeo. You're muted, Attorney Centeo. You need to unmute yourself. Yes.
Sorry about that. And I will start off by saying that this appeals court panel should affirm the dismissal of the case by the Superior Court based on the lack of standing. And let's go over the issues that was raised. And by the way, Mr. Porter has 2 cases published. He had the last one from the appeals court. He has other cases that have been published in Superior Court, in Land Court, that has litigated the similar issues. In these cases, he typically brings up increase in density, increase in traffic, or decrease in parking, noise, congestion, diminution in value to his property. These are the issues that have been presented before the Superior Court, Land Court, and the Appeals Court. And he has a couple of that have been published. The labels and conclusions does not give rise to both. He's arguing the Enabling Act and the Statute, Chapter 48, Section 11 and 17. Both requires that the person, in order to have standing, be an aggrieved party. He merely presented at the time of trial conclusions, personal speculation regarding these claims that he made about density, traffic, noise, diminution in value. And the court said that these were unsubstantiated claims and was not supported by any evidence presented at the time of trial. And that these harms that he presented were not unique to him. These were the same concerns that the rest of the community would experience. Now, let's go back and give a little bit background that the court found and the ZBA found. Linden Street, as a matter of fact and undisputed facts, it's a street that has 4 one-family. What the single-family homes in this street all are 2 stories or higher, including his. His was a single family that he converted into a 2-family, and it's directly across. But Linden Street has 7 2-families already in existence at this time. Without our project, it has 2 3-families and it has 1 4-family. So the area is zoned as a 3-family. With respect to the issue of parking, I'll start with that. That was not before the ZBA. That was not an issue. The architect did not seek the variance, and the reason for being is that it met the requirements. They sought for variances, but not a parking variance because it met the statutory requirements of 3 parking. It was not going to eliminate any on-street parking. The only thing that it did, he's claiming that there were 5 original illegal parking in the backyard that was designed by the previous owner. So what they project is going to do is legalize it into a 3 maneuverable space that cars can come in and go without having to borrow keys from anybody else. It would give ample parking and would suffice both the Enabling Act and the statute in all the cases. So therefore, at the time of trial, we had 5 witnesses. We presented 4 witnesses, including the architect, 2 architects, and also the traffic transportation engineer. The reason being for that is not because we filed a request for variance on parking. It was to show that it's not going to have any big impact on him as opposed to the minimus impact that it would have in the rest of the community. Parking was not going to be increased by this project by converting it from a single family to a 2-family. It was not going to increase congestion as the expert testified to. None of the architect's testimony or the traffic engineer testimony were rebutted by Mr. Porter. Mr. Porter was the sole witness at the time of trial. He did not present any credible evidence, as the court found, to rebut any of the presentation of testimony from our expert that the court found were credible. And with
Mr. Centeno, can I ask a question?
Yes.
Is it fair for me to assume that this project has been put on hold pending the outcome of this litigation?
Yes, and I was going to answer a lot of the questions he raised on his brief. So basically, I'm going to summarize.
Well, let me just, before you get onto those other questions, let me finish this one. And I assume that the purpose of the bond was to cover any damages that your client might suffer as a result of delaying the project. Is that correct?
Absolutely correct.
And are there such damages?
Yes, because I did the outline. I was going to cover this. It's on my, he raises that, the bond. Let me find my argument on the bond. That the court abused its discretion in establishing the bond. This case started back in 2016, August of 2016. July 2017, the ZBA approved the project. And Mr. Porter is very clever. In his first original complaint that was filed when he appealed it in August of 2017, he filed a Superior Court complaint. He listed the defendant, Fung Inshu Realty Associates, address in Brookline. On his amended complaint, he listed the same exact address. Fung and Associates is owned by Jackson Slomiak, who's on YouTube here today. He's been living at that property with his wife and children, and his biological mother also lived with them. So the purpose of this project was to build a second addition and move his biological mother, who is at an advanced age, to this new location because they're overcrowded in his Brookline address. He failed to serve the defendant, Fung Inshu Realty, for over 2 years. We subsequently learned about it, and I filed a motion to vacate. That motion to vacate was allowed on the grounds that the address was always the same on the first original complaint and on the amended complaint. So he refused to serve the defendant at the Brookline address and proceeded to get the fault and all this and all that. So we were able to show that if the fault was vacated, he would not have suffered any harm. Now with your Honor's question about the bond, because of the delay he has caused, and I argue that in Superior Court, that he intentionally did refuse to serve the defendant at his home address in Brookline, which he listed on both complaints. So therefore, he delayed it and proceeded to get the fault and do this and do that and to dismiss. Then at the time of trial, I filed a request under the statute for a speedy trial date. He tried unsuccessfully on 3 occasions.
I'm sorry, isn't the bond for delays because of the appeal, not because of the underlying case? Am I wrong about that?
It starts from the beginning how his strategy.
Isn't the bond a bond to allow him to appeal?
But also to cover any prejudice or harm as a result of the substantial delay is what I was getting to, Your Honor.
Substantial delay in appealing, or substantial, you're talking about long before judgment entered. When was the bond entered? Isn't it an appeal bond?
That is the appeal bond, but what I ask is that because he intentionally delays the progress of every case.
Have you sued him for damages?
Because of the long established delay and even in filing the briefs, it was rejected several times, despite the fact that he's done it a number of times. He has successfully appealed decisions to the appeals court, but he intentionally knows how to delay. So the cost that my client is going to incur from having a project that was going to cost over $500,000 to add the addition to the rear of the building is now going to cost substantially more because of the delay in getting the project underway. So that's why I had requested the bond, because based on my experience with him in this case from the beginning to the end, he always looks for a strategy to continue to delay or not fulfilling the deadline that we all lawyers have to comply with. At trial, he tried to continue it 3 times. In this, the filing of the briefs, he delayed it. He kept asking for more time, which I opposed and I opposed, but he still did it. He still successfully requested for additional time, and therefore that bond, to me, was done appropriately on the several grounds. One, the court found Superior Court Judge Giles found that there is no meritorious claim on appeal, and that the claims for appeal would be frivolous and not meritorious. And the delay, those are my grounds, and that he would not be harmed. If this is overturned, he gets his money back. So there's no interest being paid on these at any bank you put your money in these days. So therefore, he's not going to suffer any harm by the establishment of this bond. And if he's successful, the bond will be returned automatically to him. So therefore, I argue that the maximum amount, which was the $25,000 for a project of this size, be imposed because of his clever and delaying tactics. And he knows how to delay the system and the process in this case. So at every step of the way, he was able to try to delay and cause it. So that
These
was
would
my
be questions. Wouldn't these be questions for the trial court on remand? What to do with the bond? We don't decide that, do we?
But that's correct, based on whether or not you found that the appeal was
No,
meritorious.
assuming if he were to lose the appeal, it would go back to the trial court, who would have to have some kind of factual hearing, right?
That's correct. But I'm also asking, based on that, to tie it in, before I forget, is that I'm asking for a legal fee PSS under Rule 16, subsection 10, because of what he's been doing here. The last time when I first checked, when I encountered him, he had about 8 cases with a few resolved and a more pending. And that was my total count. And now he was asking that there was a fraud, we made a false accusations.
I mean, he wins some of them, is the thing. Right?
That the defendant made a false representation that it's an owner occupied. First of all, there is no requirement that for a variance, your project be owner occupied, because then nobody would be able to advance and get a project going, because most of these projects are owned by big developers in the city of Boston and everywhere around our Commonwealth. But in this one, we said it from the beginning, we said it at trial. The project was to build an addition for Jackson Slomiak's mother to move into, because Jackson Slomiak's family continues to grow. He has children and he's got a wife at his Brookline home. They're on top of one another. We presented that fact. That was undisputed. That was the original plan, and that is still the plan, to move the biological mother to 85 Linden Street. So that was not a fraudulent misrepresentation. That is irrelevant and immaterial and not an issue. Just like the parking was not an issue before the ZBA, we feel that the ownership statement that we represented was not false, and it's not relevant or material to the decision in this court here. And there was one other issue that he said, he limited, I only have 3 more minutes. I don't know if the court wants to hear whether or not the decision of the ZBA was arbitrary and capricious, because they made significant and specific detailed findings about the neighborhoods. They found what types of homes are on Linden Street. That, first of all, it's shown as the 3. This project could have been done as the 3, but the people said, no, I'm gonna maintain the same height as the existing two-story homes. That's how they kept it. And they said, we're gonna match it to be the Victorian. These were all the specific findings, and that it would be in harmony. And by the way, the ZBAs found that the city of Boston, neighborhood services, the local council, and the Department of Boston Planning and Development Agency all came in to support the ZBA's decision at the hearing. The only opposition was the letter that Mr. Porter submitted to the ZBA. But the ZBA decision made detailed findings about this neighborhood, about the different style of homes and multifamilies that are there. And they also made that it would be consistent with the design and surrounding neighborhood, because you will not be able to see the addition from the outside or from Mr. Porter's home. The architect did a brilliant job by tacking it in the back at same height, same Victorian details. So nobody would be able to see it. So they've made that consistent finding, and that it would not be injurious to the neighborhood or detrimental to the public welfare. So all these were done in writing, and the judge in Superior Court Judge found that made both decisions, that Mr. Porter did lack standing and therefore dismissed the complaint, and that the ZBA decision was supported by detailed findings. So on both the merits of this ZBA decision, I asked the Judge Giles to make a ruling that the ZBA decision was supported by the facts and the findings made by the board. They'll have a minute, so I don't know if you want more questions.
I see no further questions. If you'd like to rest on your brief, that's fine as well.
I didn't cite any cases. I've got all of those, the Marchinson versus ZBA of Sherburne, Spooner versus ZBA of Brookline, Picard versus ZBA Westminster, Marshallian versus ZBA of Newburyport are the leading cases. And the latest one from the SJC is the Marshallian cases. Those are the leading cases that deals with that show that Mr. Porter's conclusionary and allegations about the noise and all this are not unique to him or different from the rest of the community. And therefore, he lacks standing, and the judge correctly dismissed the case.
All right, thank you very much. We understand your argument and yours.